Hello, this is Professor Werwath. I want to go through the case study, Turn Your Science into a Business, which is from Harvard Business School Press. How to avoid some common traps that scientists often fall into, and engineers as well, when they are starting a business from a technology, when they are starting a new enterprise and not understanding necessarily all the legal ramifications of what they're doing or some of the traps that people can fall into. So here we go. Some basic advice that we often start with is, first of all, develop an IP strategy. So understand what you are protecting, what is protectable, what isn't, what you're going to patent, what you're going to protect by trade secret, and if so, start acting accordingly, almost from day one, right? Prioritize what applications and domains you want to focus on, and what you're going to be prioritizing versus what markets. So in that sense, you're going to be investing in those areas, and you're going to focus on those applications first and foremost, so that you can put your money into both the patent filings as well as the research that you're going to be doing. Develop your presentation and your pitch in such a way that you don't reveal any proprietary information. So this is a little bit of an art form, but how do you share enough to get the interest of the audience, even a technical audience, and at the same time not revealing how your technology works, right? So what is that which you're going to keep in the public? What are you going to try to protect as part of your patent, as part of your intellectual property? Form your company and your entity early. So in essence, you're not acting as an individual, you're acting as the leader of a company that will protect you as an individual from legal liability, as well as some potential financial liabilities. So if you're an officer in the company, portray yourself as such. I'm the CEO of XYZ. Make sure XYZ is incorporated in the state you're doing business in. And then make sure that you follow that in your correspondence, right? So make sure that all your correspondence has that in there. Label all your proprietary information from day one. So if you're protecting a certain piece of intellectual property, anytime you mention it, anytime it's documented, make sure it's labeled as confidential and proprietary. Be careful with public disclosures. You're making a presentation, you're doing a pitch competition. Make sure you're not giving away the farm, so to speak, and telling people too much that already is part of your protected IP. That alone could invalidate your pursuit of a patent, your pursuit of protection for your intellectual property. So don't undermine your own efforts to protect your IP. Get legal advice early. In the case of Northwestern students, you can get that from the Northwestern Legal Clinic, and it's usually very low cost. And even the first hour might even be free of charge, right? When you start hiring people, paying people, signing contracts, this is when you know that you're, quote unquote, starting to do business. And this is when you need to be incorporated. And this is when you need to have some standard forms available to you from your lawyer in terms of standard form contracts, standard form hiring agreements, et cetera, et cetera. So, and don't underestimate some of the legal implications of just hiring people and labor regulations, right? So you can't have, for example, two people doing the same job with different titles or with different pay grades or different salaries. So just make sure that those jobs are differentiated and they're documented so that you can protect yourself. Some of the traps, right? So first of all, avoiding public disclosure. I think I mentioned that, right? Require contributors to sign non-disclosures. So people who are contributing to the work or people who are exposed to the work should be signing a non-disclosure agreement. That could be one of the first forms that you get from your lawyer, or at least get a good form from a legal website specific to your state. Require non-disclosures where needed with third parties, right? So you're dealing with any third party supplier or maybe a contractor, make sure that they too are signing NDAs, right? Developing the product, over relying on known science, right? Try to develop and demonstrate a novel application of scientific principles or materials. Otherwise, you're not going to have anything, patentable. I mean, the first rule of patentability is it has to be novel, it has to be new. You cannot patent a mere idea. On the one extreme, on the other extreme, it does not need to be reduced to practice. You don't actually have to build it to be able to patent it. Failing to demonstrate originality, Managing attribution, make sure people who are contributing have been given credit, right? So you don't want to freeze people out because it'll come back and bite you later, right? Formalize IP ownership prior to commencing development. We just had that happen in one of our classes where the student brought IP into the class, wants to make sure that he and he alone has ownership rights to that, right? Neglecting policeability, right? So indelible marks of an invention into the product, license the process invention to producers of a larger system. So make sure that you have a way of distinguishing your product and technology from others. Going to market, right? Failing to secure the best territory. Pursue the most promising markets early. We call this the beachhead market. File provisionals. A provisional patent is a stake in the ground. It's not it's something that lasts forever. It usually lasts only about 12 months, but it gives you a cheap and easy way to secure kind of like the IP beachhead, if you will, before proceeding with a full-fledged patent. License your technology into domains that are lower priority. So this is one way of funding your startup, is to license your technology into markets that you're not really planning to participate in. Falling into the funder's clutches, right? So you have a grant, you want to grant your funders initial royalty-free access to the invention for limited timeframes only, right? So if they're going to be expecting access, make sure that that access is constrained, both in terms of application and timeframe, right? Grant them a share of the licensing income so that they feel like they have a stake in the game, and file for provisional patents before applying for funding. So make sure that you have some secured your rights, right, as a patent holder before going after funding and exposing your technology to potential funders. There's something called the corporate veil, right? This is what protects the officers and managers of the company from personal liability. So this only works if you act in concert with the corporate veil. If your personal interactions and your professional interactions are intermingled, right, that could be very confusing, and also it could undermine your own attempt to maintain a corporate entity. So make sure that you minimize your risks by following industry best practice or developing better practices, consistently following them. Do all you can to ensure safety and efficacy and truthfulness in all your dealings, especially with investors and customers and employees, right? Set policies as best you can and enforce them as best you can so that your whole company is acting like a company and not like some sort of group of, I guess, group of disconnected people, right? So what you want is a company that's acting as a whole, that's acting in concert with each other, right? Different types of incorporations, subchapter S, subchapter C, LLCs, LTDs, and the state of incorporation. These are all the types of questions that a lawyer and your team will be diving into. So, and this is why I say get early advice from a lawyer. You're going to want founders agreements where you have multiple founders. How will you allocate the proceeds of the company? What happens if one of the founders steps away or gets ill or dies? So you need to have contingency plans and thought through agreements that are well understood upfront. There's obviously a whole host of labor law issues. You need to understand the difference between exempt and non-exempt employees, for example, right? The role of the job description, the role of performance reviews. How do you terminate people? How do you legally hire people? What can you say in an interview? What can't you say in an interview? These are all questions that a labor lawyer can help you navigate so that you're not getting your company into trouble from day one. Contracts, subcontracts, leases, employment agreements, NDAs I mentioned before, non-disclosures, and of course, patents, trademarks, and copyrights. These are all areas that I think of the law clinic, the Bloom Legal Clinic in Northwestern University downtown, is available to you as a resource. It's definitely discounted, and I think there's a certain amount of free access you might have up front for maybe the first hour or so to help scope out exactly what you're going to need as an entity, as a company. Why is patent litigation so difficult, right? So if you get into trouble with your patents and you have to litigate, you're going to find that the big players have the big money, right? So how do you go up against them? You're probably going to have to get somebody who's going to take your case on a contingent fee basis. So Not too many law firms will do that. I guess if there's a solid case, they might entertain such an arrangement. Big players can outspend their opponents, and that's always been the case. So don't be surprised when the big players abscond with your technology in the hopes or the expectation that you won't do anything about it, because patent litigation is both difficult and expensive, right? Brazen acts by big players often go unresponded. That's another way of putting what I just said, right? And you'll see some examples in the next few slides, right? There is something called the Patent Trial and Appeal Board where you can pursue your litigation. The game must be played and played well from the beginning. So how you frame your patent, how you submit your filings is all perhaps the most important thing you can do, because that is what's going to make you vulnerable or less vulnerable, depending on the circumstance, right? We are a first to file country, not first to invent. That changes quite a bit how you operate. In the past, it used to be documenting in a notebook everything you've invented, but now it's much more focused on what you've actually filed. So you can be the first to invent, and still, if you're not first to file, you're not gonna prevail. Get your filings in early. Use a provisional if you must. Be careful who you share your inventions with. Ideas are not inventions. Reduce to a level of detail that can be protected, but don't wait until it's reduced to practice. You can actually reduce it to a level of detail before you actually have it perfected, either on the bench or in the field. Some examples, right? Gordon Gould versus Arthur Charlow and Charles Towns. Gould was a grad student at Columbia. He developed the first practical method for creating a laser. He didn't patent anything because he thought you had to build it before you could patent it. Unfortunately, his colleagues went ahead and patented it, and he fought them for 30 years in legal battles, and he eventually did prevail. And he was then issued 48 patents, but also several $1 million in royalties. But can you imagine fighting a legal battle for 3 decades? So this is, again, one of the pitfalls or mistakes people make. You can file early. You do not have to wait for it to be actually, built and physically working. Intermittent windshield wipers. I think there's been a movie on this. Bob Kearns, Ford and Chrysler. He invented these windshield wipers, but only to find that not only did they reject him in his business offerings, they went ahead and ripped him off. So they, wound up being sued, and eventually Kearns did win, but it took how many years? So it looks like about 18 years before he was able to prevail with $30 million in compensation. So it's not unusual for the big companies to think if they see it, they can take it, because who's going to fight them? I guess that's their thinking. So just beware and protect yourself as best you can, right? Apple versus Xerox. This has been, I guess, part of urban legend for some time, that Apple ripped off all of Xerox's IP. But, frankly, Xerox was paid to give access to Apple, and all of their IP was exposed to Apple by design, right? With the idea that if Apple can bring it to market, they will probably monetize it better and faster than Xerox would. So the first Apple Mac did include a lot of technology, including the GUI and a lot of the mouse technologies that we take for granted today. Did not come from Apple per se. It came from Xerox PARC. With that in mind, and having said all that, you can reverse engineer products and technologies. There are legal ways to do so. The IBM BIOS is an example of that with Compaq. Compaq took the BIOS and through interacting with it was able to deduce how it worked by not hiring people from IBM or experts from IBM, but instead using good engineering principles. They were able to figure out and deduce in a very clinical way how that BIOS operated, and they were able to reproduce it. Otherwise, we would have never had clones. We probably would not have had the PC industry that we have today. So with that, that's all I have to say about this case. I'm sure if you have any questions, I'll be able to answer them either inside class or outside class. Thanks a lot. Bye-bye.